Morning, Graham.
Morning. Take that down. Okay. All good to go at my end.
Simon Heinsohn's having trouble connecting to the internet. It's a problem at our end at the moment, but we may need a minute or two if that's acceptable.
Well, good morning, everyone. I think if we have a short, allow you 5 minutes, Mr. Finlay, and we'll try to start off at 9:35. Graham, I don't know if you can be of any assistance, but we'll take a 5-minute break. It sounds as if it's your end, Mr. Finlay.
It definitely is, because the other of us in the room have all connected, and Mr. Heinsohn realised he had a problem about 5 minutes ago, and he's just trying to get his computer started up again. But 5 minutes would be grateful, and I apologise to everyone who'd assembled for the early start. But we'll do our best.
Okay.
Thank you. I think that's Simon in now. I should say that Mr. Heinsohn was here the earliest of us all today, so it's not just firing his computer up late. He was here from about an hour ago, so apologies for that.
Okay, good morning to everyone. For those tuning in on the webcast, this is an overrun from yesterday. This is day 2 of a policy hearing with regard to energy and planning policy matters and economic benefits. I'm not planning to do introductions today for any of those watching online. You can tune in and see them yesterday. But I am joined by representatives from the applicant, the Council, Nature Scot, Cairngorms National Park, Mountaineering Scotland, and John Muir Trust and Wildland Limited. The only procedural matter I have today is that I have received, Mr. Finlay, the Nature Scot staff's CVs. So that has been received, so thank you for that. So I was just planning on continuing on where we left off yesterday to go straight on to agenda item 4 on the agenda. But before I do that, I just want to check that all the parties don't have any procedural matters that they would wish to raise just now. So please raise your hand if you've got any procedural matters. No. Good, let's move on then. Item 4, the National Park. And the first question is really, I just want to make sure that there's no disagreement that the Act itself, the 2000 Act, the National Park Scotland Act, is relevant. Do all parties agree that that could be relevant to the Minister's consideration of this case? I just wanted to make sure that no party disagreed that the Act itself isn't relevant. So if anyone's got anything particular to say on that, raise your hand. If not, we can just move on, because I'm quite clear on the implications of that act. Okay, I'm not seeing anyone contributing. So item B, where we will have a bit of discussion, is just to get clarity on the policy test for developments of this nature, which are outside the national park. I think it's agreed in paragraph 212 in SPP, and the council and the applicant are agreed in the statement of agreed matters. So I just want to be clear that all parties are happy that that's the test, and indeed just ask parties' opinions on paragraph 213 in relation to what is said in paragraph 85 of SPP. So you may wish to get a copy of the SPP out. So that's core document 4.1. And if we go to paragraph 85 on that, I forgot to write down the electronic page.
27.
At the end of paragraph 85 there, it indicates that paragraph 213 also applies to development out with a national park that affects the park. Does everyone agree that that is relevant to this case? Mr. Trinick?
Yes, so that is agreed.
And Mr. Finlay?
Yes, so that's agreed. I would like to ask at some stage, this may not be the appropriate, Ms. Godry, to comment on your the words effects on the park setting.
Yes, that's coming next, actually, Mr. Finlay. The well, not quite next, but paragraph 196, just to be clear, that is everyone in agreement that that relates to development plans, and that's not relevant for us. So is paragraph 196, that's not relevant. Everyone content with that?
Not quite so, no. Although we'll come on to talk about that in the context of the National Park Partnership Plan and Policy 3.3 later, unless you want me to say anything now.
I'm happy that you bring it up at the point that you had proposed to bring it up.
Makes sense.
Well, let's go on to that matter of setting. Then I think Mr. Bell has mentioned setting in his hearing statement, and the National Parks hearing statement is quite clear that that's not a test with regard to SPP. So perhaps I can just ask the applicant to consider whether they think setting is a matter to be considered as far as SPP is concerned, and then we'll bring in the national park. Mr. Trinick.
Thanks, Mr. Bell, for that.
Yes, I think as we've just referred to setting at paragraph 196, sorry, I'm just getting something off my screen. That relates to development plans, and it's clear the direction is for planning authorities not to create policies that would result in buffer zones around areas designated. The reference to setting is important as well, insofar as it would not be appropriate for policies that are applied within the park to be applied out with the park, or policies in the National Park Plan, in effect, to create a buffer zone. So my reference to it is in that context. I think also it's relevant to note that the previous version of the National Park Plan referred to in its previous policy 3.3 setting, effects on setting. And the park moved away from that and now has the wording that we have in 3.3 in terms of effects on significant effects on special commentaries. So the relevance of setting is in that regard, I would say, insofar as it relates to how policies may or may not be applied.
Mr. Finlay, with regard to setting.
Well, I think setting is, it's not from a legal perspective, setting is not a test. It's not a relevant consideration. I think the applicants appear to be very anxious to about the creation of buffer zones, but the park, as Mr. Bell has made clear, has steered away from that. But I will ask Ms. Cowdrey to respond more fully.
Yes, good morning, sir. In regard to assessing the effects on the national park, one should assess the effects on the national park, not on its setting. Setting is not referred to in SPP or in the National Park Partnership Plan. The Partnership Plan policies, which Mr. Bell is intimating seek to create a buffer around the park, do not seek to presume against any sort of wind farm development that is out with the park that may have significant effects. The Park Authority recognised that wind development in proximity to the edge of the park could cause significant effects. The policies are not seeking to presume against any such development. They're seeking to judge each case on its merits. And referring to Mr. Welch's inquiry report, paragraph 611, where he has a list of wind farms, under cross-examination, it was agreed that the Park Authority had objected to 4 out of the listed wind farms. This demonstrates that the National Park Authority, in applying policy 3.3, is judging its case on its merits.
Thank you for that, Ms. Cawdrey. Mr. Trinick or Mr. Bell, do you have anything to respond to that before I ask Mr. Kelly or Dr. Gordon?
No, sir. We'll come back to the National Park Plan later, I think, as you said.
Mr. Kelly, anything from what you've heard with regard to SPP buffers or setting?
Thank you, sir. Whilst I have my own views on these things, my clients are not presenting any evidence on effects on the national park, so we would not intend to contribute to this agenda item of 4 unless you had a specific question.
And Mr. Gordon, Dr. Gordon?
Yeah, like Mr. Kelly, I have no special contribution to make on this item, or indeed on this morning's agenda generally. So in general, sir, if you simply either ignore me or just look for a thumbs up now and then, that will be sufficient.
Thank you for that, Dr. Gordon. I was just saying that we can move on to item C now on the agenda. There seems to be agreement that there is a statutory duty to have regard to the partnership plan with when we're making decisions, when ministers are making decisions. No disagreement with that, is there? That regard should be had to the plan in this case. Mr. Trinick?
Sorry, so we're slightly behind time. We missed something you said there. Are we on to item C now?
Yeah.
Sorry, Mr. Trinick. I was just saying that there doesn't seem to be disagreement that there is a statutory duty for ministers to consider the partnership plan when making decisions.
That's agreed. It's in the Act.
The other matter there is there any guidance on the weight or any requirement to comply with the plan? And do the parties have any particular view on that? Maybe if I come to Mr. Trinick first, and then.
Yes, certainly. There appear to be two policies of potential relevance in the National Park Plan to consider. We go to document CD48 and to policy 1.1 initially, which is physical page 41. Someone can help me with the electronic page number for that, but policy 1.3. Now, to be fair, this is not referenced by the National Park Authority. It is a policy across which you may come. And have you got it, sir?
Yes, I have it. Yeah.
We say that this set of policies, it does not have a relevance for the proposed development because it solely addresses the conservation of matters within the park, as opposed to development outside, but potentially affecting the park. If there's I don't know if there's going to be a debate about that, but I think we ought to set out our stall in relation to that set of policies, in a particular 1.3, which does refer to the special landscape qualities, hence going to it. We say, no, that's not relevant, that's about conservation within the park. The other set of policies is the policy 3 set, which is on certainly physical page 75 of the plan, which is referred to by the National Park in its objection, policy 3.3, and in particular 3.3a. And we acknowledge that there is a relevance to this policy, but it's not a question of applying policies for the park outside the park. The plan is indicating here the interests which it seeks to preserve within the park. And therefore, it's a material consideration. But it's not a policy to be applied because we're not within the national park. And to the extent, and this is the point I was going to make earlier, that I heard what Nina said, and I welcome what she said. It's every case on its merits, and appreciate that. But to the extent that there is any effort to apply this policy to development outside the park, that would be the creation of a buffer zone. I'm not saying the park are trying to do that, we'll hear what they have to say. But clearly, the word significantly adversely affecting its landscape character or special landscape qualities is a material consideration. It's verification of the interests which the park is seeking to protect. So that's as far as it goes. Thanks.
Mr. Finlay, do you have anything in response to that?
Yes, sir. Firstly, I accept Mr. Trinick is correct that policy 3.3 is the only policy referred to in the park's objection letter, but policy 1.3 is referred to in its hearing statement, and I believe in the report that went to the park body. And we consider that it is relevant for the reasons outlined in the hearing statement and in the report. And Ms. Cowdery can add to that if she wishes once I've finished. As to policy 3.3, it's clear on its terms it's relevant, and it's relevant because for two reasons. The Act in section 14 makes the park plan relevant, and this clearly applies to it. It's not creating a buffer zone. It clearly is a material consideration. We're not in a development plan policy world, so like the Highland-wide local development plan, the park plan is a relevant material consideration and capable of being one which significant weight can be afforded. Whether it is or not will ultimately be a matter of judgment for yourself. But in effect, it's no different from the Highland-wide local development plan, about which there is unlikely to be any disagreement. The extent to which this policy is engaged will depend upon, in part, upon the judgments you make on the disputes between Mr. Welsh and Ms. Anderson. So that's all I was going to add. I just see if Ms. Cadry wants to add anything else. No, she doesn't.
Mr. Trinick, just to be clear on your position on policy 3.3, do you, if you go to the National Parks hearing statement, I think it's in paragraph 32 of CD 14.4, do you agree with that paragraph?
Let me just go back. So this is CD 11.
It's 14.3 and it's page, sorry, paragraph 32 of the National Park hearing statement.
Yes, it's 14.4, I think.
14.4 and it's page 8.
Thanks, I was getting to it. The
Paragraph 32. Which reiterates what was said, but are you in agreement with that paragraph?
Well, first of all, I acknowledge that Section 14 of the Act requires us to have regard to the plan. No question of that. Secondly, therefore, policy 3.3 is we have to have regard to it and it is of relevance. My only concern, and I acknowledge that the National Park Plan is not a development plan as such, is that there shouldn't be an attempt to directly apply policies made by the National Park Authority outside the park. I think it's a more general planning principle as opposed to something deriving from the precise status of the plan. So there couldn't be said to be, well, it's difficult under Section 25 anyway, but there's not a direct conflict with the policy. If you find in favour of the park, it will be because there is a conflict with the objectives of the plan. That sounds a rather legal point. It probably is. So I don't think that in substance there is anything between Mr. Finley and I'm just making a somewhat technical point about the application of policies within a plan outside the jurisdictional area of that plan. That's all I'm saying. It may have no effect in terms of weight at all.
Thank you for that, Mr. Trinick. In item D,
So can I just, it may be you don't need opposition made clear, but can I just say two sentences? Firstly, this special qualities can be affected by development inside and outside the park. And there is nothing jurisdictional about the requirement to take into account the park plan, the development outside the park, conflict with policy 3.3 can be a relevant consideration.
okay, thank you for that, Mr. Finlay. I have that point.
I don't think there's any substance between us on this, so I'm not nothing more to say.
Thank you, Mr. Trinick. Item D now was just to clarify the applicant's position, and I've put a couple of references there, I think, to Mr. Bell's hearing statement, paragraph 534 and 535. Is there any particular clarification required for that? Are you saying at 534 that you consider that there are significant adverse effects on the qualities And does that relate well to 535, which you're saying that it's judged to be acceptable? I just want to be very, very clear on what you're saying there, Mr. Trinick.
So, hello, Mr. Bell.
So that the reference at 534 links to previous paragraph in terms of paragraph 212 of SPP. So it's simply referring back to that second limb of 212.
So the primary position of the applicant, as I made clear in yesterday's session, is that there is no significant adverse effect on the overall qualities of the area, such that the second limb of SPP 212 is necessarily engaged. That's a matter of evidence. If you find against us, subject to the way you approach SPP 212 and the differences between Mr. Fenley and I at this point, I don't know, then you need to consider the balance of the second limb of SPP 212.
So just to be clear on that paragraph 534, is that accurate then? That are you saying that there are significant adverse effects on the qualities as identified by Mr. Welsh? Sorry to probably ask the same question again. Is that a statement that is accurate as far as your case is concerned? Sorry, you're on mute, Mr. Trinick.
Yes, Mr. Bell.
It's the reference to Mr. Welsh's evidence, where it's the limited localised effects on special qualities, distinct from effects on the overall area. So that is the reference. Should that limit be engaged, which we say there is no need to, because as Mr. Trinick said yesterday, in terms of the two routes to consent in paragraph 212, we consider we passed the first route in that policy test.
Okay, so that's something different to what's said there, or because I think you're saying there that those significant adverse effects are clearly outweighed by benefits of national importance. So is that statement inaccurate?
It perhaps could be phrased better in that if in the alternative, if you were to go on to that second test and engage it, then that would be our position because of the evidence of Mr. Blackett, where the benefits, as we explained yesterday, would be clearly outweighed. The effects would be clearly outweighed by the benefits that would be of national. Sorry.
I was just going to refer back to your 5210, where you say the limited extent of significant effects on the four special qualities. So there you are indicating there are limited significant effects, but that wouldn't adversely harm the overall objectives. I think that's what Mr. Trinick is saying. Perhaps if I ask the council for their view, and then I think we will go to paragraph 212 of SPP, just to be clear on the parties' understanding on how I should approach the two limbs as they're referred to. But first of all, Mr. Finlay, on what you've heard from the applicant.
Well, I believe I understand the applicant's case, which is that neither limb of 212 are engaged, and and I'm grateful for Mr. Bell's further elucidation of 5.3.4. But in our submission that the concentration, Mr. Bell suffers from the same flawed logic that I put to Mr. Welsh, not surprisingly because he relies on Mr. Welsh, and his reference to effects on the overall area is not the test. The Park statement at paragraphs 45 to 51 set out, in our view, the proper approach to meaning of integrity and approach to integrity by reference to the Catholic reporter. And I put those points in cross-examination. I won't repeat them now. As to 212, it requires a consideration of the planning balance, which the park is not primarily involved in, but we say the second test has failed, wearing the wearing Nature Scott and THC's hat. They consider that there are impacts on the special qualities, and they're not. The second part of 212 is failed as well. But our primary position is that you don't get to the second part of 212. All three parties consider that the application fails on the first limit, 212. I'll just ask Ms. Cadry if she wants to add anything to that. No, she doesn't. That's
Well, perhaps we could go to SPP 212 again. I think, Mr. Trinick, you indicated that you might wish to comment on the proper interpretation of that paragraph. So if we can all go there, I think that's on electronic page 52. So do you have anything in particular to say to me in terms of how to interpret that policy with regard to this case, Mr. Trinick?
I hesitate to do so, because I think that 212 is not brilliantly written. It could have been clearer in terms of the way it's supposed to apply. But I am certainly not going to try and put myself in the position of the author of 212. I can't do so. And therefore, I think I must accept the approach of Mr. Bullier at Catholic to the application of this test in the paragraphs to which Mr. Finney has referred. I'll go with that for want of anything clearer in SPP 212 itself. I don't want to try and engage in some parsing of the paragraph. I'm not sure it's going to help you at all.
Well, I think it's helped in that you've agreed with Mr. Finlay that there is an interpretation there in a previous case that you both agree with. So I'm content to have that evidence from you. Before we move on to the, can you hear me, Mr. Trinick? You might be talking to someone else. Okay. Item E, I think we've possibly covered, but the applicant, a question to the applicant, if the applicant isn't saying that there is a conflict with the park plan, are they? I think Mr. Bell, in his statement 742 of Mr. Bell's statement, indicates some conflict with the policy.
Mr. Bell?
Yes, that's set out there that the view can be taken that because of the literal wording of policy 3.3, that there's some tension or conflict with it. But the key point is that, and this is very well set out in the Dornell inquiry report, which it may be worth going to.
Well, just before we do, I think in paragraph 7.4.2, contrary to what Mr. Trinick said, you're saying there might be some conflict with policy 1.3, and Mr. Trinick had said that that isn't relevant as far as you're concerned. So was that a mistake, or Was it
Yes.
just
Point was one, a technical one of direct conflict with the policies of a plan outside of this area. Mr. Bell's absolutely correct. There is a tension with the advice in the plan regarding significant adverse impacts on landscape and on special qualities. That's what we're saying in the evidence.
Yeah, so a strict reading of the planning policy from the planning perspective, how the wind farm would not conserve, and in terms of the localised limited effects that Mr. Welsh has highlighted, that engages policy 3.3. But I think it is helpful to have a look at the way policy 3.3 was looked at by the chief reporter in Dornell. For Dornell is CD 9.34, and in that, paragraph 6.117, it's quite a parallel situation where the effects on the special qualities were localised. However, the reporter highlighted that the policy does not apply any additional considerations or balance beyond the recognition of, are there significant effects or not. So helpfully at paragraph 6.119, the reporter acknowledged that even although there was conflict with the plan, the park plan, with regard to policies 3.3, 1.3, they did not consider, as the two reporters, that demonstrated unacceptable conflict with the overall objectives or with the aim of the park. And that is read really as the objectives of designation for the purposes of paragraph 212. And at paragraph 6.120 of Dornell, it is also helpful because the reporters there also set out that they did not take the view that there would be unacceptable impact on the objectives or integrity of the park as a whole. So I think that is, in my view, a sensible approach, a reasonable and well-reasoned approach, and it fits with what the National Park has said this morning in terms of considering each case on its merits. Therefore, it's also instructive when looking at the matter of integrity. So a limited effect, localised effect, as Mr. Welsh has set out, does not necessarily go to undermine the integrity. So that fits very well with the evidence of Mr. Welsh and is consistent with my policy position and the position of how paragraph 212 of SPP is applied, and indeed here 3.3 of the park plan.
So if I can add to that, while you've got Dornell open, there is a point within paragraph 6.118 where I hesitate to say that the chief reporter, I'm not sure, did get it right as a matter of law. I think that needs to be noted. He said in David rather, because I was on court as well, said in 6.118, however, even where there is conflict with the policy of the park plan, the statutory requirement is not to secure compliance with this plan, but rather have due regard to it. So far correct in terms of section 14 of the National Parks Act 2000. He went on to say, indeed, special regard is to be had to the desirability and consistency of the park plan. That is not correct. The special regard duty can be found within what is now section 264A of the 1997 Act, introduced by the National Park Act 2000 in Schedule 5, paragraph 18. And that section says, in the exercise with respect to any land in a national park of any power in the planning acts, special attention should be paid to desirability, etc. So that test only applies to development within the national park. So I think, although I entirely support what Mr. Bell says about the approach of the Dornell reporters to the issues in that case, there's an incorrect rehearsal of the appropriate statutory test. or not test, but have regard to test. Excellent.
Thank you, Mr. Trinity. Mr. Finlay, is there anything that you would wish to respond to there?
Can I respond in three parts? First of all, I think I'll need to consider Mr. Trinick's legal submission using a review of his submission, and I will deal with that in closing submissions insofar as I need to. I'm not necessarily saying he's wrong or that there is a dispute, but I'd like to consider what he's just said because I don't think that's set out anywhere else so far. Secondly, by way of overview, there is nothing in the Dornell reporters either report, because I think you've got both reports before you approach, which is inconsistent with the park's approach. And in our view, both Mr. Bell and Mr. Wells seek to take too much from what are in fact conclusions, site-specific conclusions, and seek to apply them in favour of an approach to the park plan and SPP, which is not warranted, so as a matter of generality. And I will thirdly ask Ms. Cowdery if she's got anything further to add on the specifics of Dornell or the comparison.
Yeah, it's just to reiterate the point that I'd made earlier this morning, that each case should be judged on its merits, and clearly that's what the reporter has done for Dornell. Like I said, wind farms in proximity to the edge of the park will have a significant effect, and therefore you need to make a judgment as to how significant they are. Clearly in the Glenshero case, we have considered that the nature and significance of the effects do cause a failure with policy 3.3 and 1.3. That's in contrast to the applicant, who seems to be confusing matters slightly with policy 212 in SPP, which isn't particularly helpful for how I get to describe how we apply our policy in terms of the park. What I would say in relation to balance, which was referred to by Mr. Bell, is the park partnership plan is seeking to discharge its duty required under the Act. It is required to fulfil the 4 aims of the park in a collective and coordinated way. It is not required to look out with those aims, unlike SPP.
Thank you for that. I mean, that perhaps takes me on to the next question, actually, around where significant adverse effects are found on SLQs. Does that then almost automatically mean, from your perspective, that the Act, the plan, and SPP would not be satisfied? So, or would there be cases that significant adverse effects could be found, but they're judged not to be so significant? Or is it always going to be the case that if there's an assessment that significant adverse effects are found on any of the SLQs, then the integrity would be questioned and it would fail the tests? So that was my point in item F, was just to clarify that, are you saying if any significant effects occur, that means it would fail those tests in every case? Mr. Finlay or Ms. Cawdry?
No, sir. In relation to the policy, it's not, as I said before, it's not presuming against any development that has significant effects. We need to make a judgment as to the significance of those significant effects, if that's not too many significances in one sentence. So you judge each case on its merits. Clearly, a wind farm in proximity to the park will have significant landscape and visual effects on the SLQs. But that doesn't mean necessarily that it would fail the policy. It would be the significance and nature of those effects that we would reach a judgment on.
Mr. Finlay, were you going to add something?
No, I think Ms. Cowdrey's expressed that extremely clearly.
I didn't quite hear you at the end there. Maybe you weren't close enough to the mic.
She's expressed herself well and clearly, and I don't have anything to add.
Mr. Trinnickland, do you have anything in response to what you heard from Ms. Caudry?
Yes, sir, I do. Looking at your precise question in 4F, clearly the section 14 duty is to have regard to. I think we're all having regard to that duty in this inquiry. It's section 1 of the Act that we need to refer to in terms of the aims of the park, and cross-referencing to STP 212, looking at the objectives of designation, which I think we both interpret as meaning the aims as set out in section 1 of the Act. Integrity, which I think there's no great dispute about what integrity means. And then the second test of significant adverse effects on the SLQs of them. And the point I want to make here, and there are no surprises here, because I made this point in cross-examination with Carol Anderson very clearly, and signalled that I would raise it in this session. It relates to the extent to which, in this session, any person on behalf of the park or Nature Scott can draw overall conclusions in terms of section 1 of the Act. Because the only evidence which has been brought before the inquiry relates to the first aim to conserve and advance the natural heritage of the area. If you want to do cultural, that's fine, certainly the first aim. And the only person who gives any evidence in relation to that aim is Carol Anderson. The landscape and visual evidence she gave. Nobody else gives that evidence, and I put to her in cross-examination that if there were to be a conclusion in relation to SDP 212, only she can provide evidence of that conclusion in terms of significant effects on the SLQs of the park as a whole, in terms of aims, in terms of integrity. And I would be very curious to see how anybody else could reach such a conclusion in the absence of a conclusion from her. I'm afraid I have to say, I think that the Nature Scott and CNPA are disabled in this section from reaching a conclusion in relation to that aim, and therefore in relation to section 1, because there is no evidence in relation to any breach of the other aims, sustainable use, understanding of employment, special qualities, the public, maybe ANC, but that relates back to Carol Anderson's evidence anyway, and promotion of sustainable economic and social development of the area. I'm not sure how those opposing this can possibly reach a conclusion in this session, the absence of conclusion by Carol Anderson.
Mr. Trinnick, sorry, I am sorry to interrupt, but I think we may have lost some of the council representatives. I've just had a message from IT, so I think you may be repeating that in a little while, but let's see if they can come back. I see Mr. Finlay appearing. Can you hear us, Mr. Finlay? He's reconnecting.
See you.
Ms. Caudry, can you hear us?
Yes, we had the hotel's internet went down, so we all lost our internet. So I've come back. We're back on the hotel internet.
Mr. Finlay, you are back, but your sound quality is not that great. So
that's because the 4G is not as strong as the hotel internet. What did the hotel say?
I think
perhaps it would be.
I think what we'll do is we'll take a short break and allow Mr. Trinnick to come back and make his points once again on these matters, and hopefully that pause will allow us to reconnect. Mr. Trinick, are you okay with that? I'll ask you to make those points again.
Yes, sir.
So I
absolutely.
think the hotel internet's just come back on.
Well, what we'll do, given that we're just about up to the hour, we'll come back at 9:30 and then we'll continue then. Oh, so 10 minutes time, 9:30, 10:30, 10:30. Thank you, Mr. Gordon. Well, that's just past half past 10. Can all the parties hear me? Is Mr. Finlay back up and running? Mr. Finlay, could I perhaps ask yourself or one of your team to just say something to us so we can understand that that we can hear you? So
Yes, I can hear you. I don't know whether you can hear me.
it sounds a lot better than it was. So it sounds as if that's been solved for the moment. I'm going to hand back over to Mr. Trinick. I'm going to ask Mr. Trinick to go back to the start of the point that you were making, because I'm not sure the council caught much of that at all. So if you could go back to the start of the points that you were making, and I'll ask the council to respond in due course. Mr. Trinick.
Thank you. So yes, the point I'm addressing is really the ability of those opposing this, the nation's God and National Park Authority, to draw any conclusions in the evidence on the issues of objectives of designation, otherwise known as aims, the integrity of the park, or in terms of level 2 within SVP 212, significant adverse effects on the SLQs of the park. I don't mean the study area, but of the park. There are no surprises here to anyone, because I dealt with this in cross-examination of Carol Anderson. And where in her inquiry report she has said that she did not draw any conclusions on integrity, objectives of designation, because that would be a matter of a hearing session. Now, looking at the aims of the park in section 1, and I think it's no dispute that the aims of the park can be otherwise called objectives of designation. There are 4. One is conserve and enhance the natural cultural heritage of the area. That is a matter on which only Carol Anderson has given evidence. Second is promote the sustainable use of natural resources of the area, which I don't think is in dispute between the parties. It's not been a topic of evidence. Third aim, promote understanding and enjoyment, including enjoyment on recreational special qualities of the area. Well, I can see that can come into play, as that's a matter for Carol Anderson's evidence as well. And D, promote sustainable economic and social development of the area. I don't see that in any of the evidence as being an issue between the parties. So in terms of drawing overall conclusions on the evidence, only Carol Anderson, in my view, could do so. And almost offered her the opportunity in cross-examination to do just that, and the opportunity was not taken. Now, looking at CD 530, which is the guidance for assessing effects on special landscape qualities, there are a number of steps, which is to, if you look at Annex 1 is a good place to go on electronic page 5. You look at what the proposal is, then you define the study area. Step 2. Then you carry out your assessment. Step 3. Step 4 is a summary of the effects on SLQs, implications for the national park, possible future effects on SLQs and recommendations for further mitigation. If you go back to paragraph 34 of the document on electronic page 4, it talks about that final stage of drawing together all the strands of the assessment to present a summary, evidence to inform the decisions on policy. The narrative should cover the following issues, and those are set out. And paragraph 35, from the judgment above, the statement of effect should be reduced. Significant effects have been identified with the following SLQs. What does this mean for the study area? What does this mean for the wider designated area? Now that is where I would have expected Carol Anderson to draw conclusions on the overall impacts of the development on the national park. She did not do so, explicitly declined to do so. So I'm afraid my argument is that the National Park Authority and Nature Staff are disabled in this session from taking the matter any further because they do not have the relevant conclusions from Carol Anderson. Another document informs what I'm saying. If we go to JW23, which is CD 12.3 to CD 12.3.2, that is a map of the Kendalls National Park. Now, it hasn't got the study areas. Tell me when you get there, so sorry, I apologize. Going too quick.
Could you give that reference again, please?
Yes, of course, CD 12.3.2, JW23. It's electronic page 10. Are you there, sir? Thanks, sir. Now, that doesn't show the study areas, but you'll be familiar with the study areas from the evidence already given. What that shows is the full extent of the park, I think, goes about 100 kilometres east of the outer boundary, Carol Anderson's easternmost study area. So the study area is very small compared with the park. That doesn't mean to say, I'm not arguing that effects on the park can't be effects on the whole. That's not the issue. And indeed, small effects can be effects on the whole. Let's have that debate. But the issue is the ability of the park, based on the evidence of Carol Anderson, to draw any conclusions on integrity and objectives of designation or overall effects on the SLQs. And even if it were to be argued that in this session somehow conclusions could be reached on aims B and D, were they to be relevant, the one thing that simply cannot be done is to draw conclusions on integrity and objectives of designation for aims A and C, because that is wholly reliant on the evidence of Carol Anderson. It's been a concern to me from the word go, and that's why I cross-examined Carol Anderson on the point. I wanted to know what the National Park and what, or rather Nature Scott, she represented Nature Scott alone, what Nature Scott were really saying about SPP 212. And the answer is I don't know. And I'm afraid it's too late to tell us. Thanks.
Thank you, Mr. Trinick. I know you've indicated that your view is it's too late, but I am going to ask Mr. Finlay to respond to your points. Mr. Finlay.
Yes, sir. I think Mr. Trinick has certainly highlighted an area of disagreement, but he's, in our view, significantly mistaken in his approach. If I could take you back to CD 530 and paragraph 34, so that's electronic page 4 of 30. You will, Mr. Trinick identified, in fact, the most relevant words that the final stage, paragraph 34 reads, draws together all the strands, etc., evidence to inform the decisions on policy. And as you will recall, Ms. Anderson, unlike wild land areas or special landscape areas, considered there was a policy overlay, which is why she didn't herself reach a conclusion on integrity. And indeed, I cross-examined Mr. Welsh to the contrary effect, that it really wasn't for him to do, and that he'd misunderstood the policy approach and hadn't applied the approach in Catholic, which Mr. Trinick has agreed this morning. So in our submission, Ms. Anderson did exactly what a landscape architect should do and has provided you and the ministers with the assessment from which can inform decisions on policy. And so she's complied exactly with the SNH guidance in that regard. The park, in its report, which is CD 2.4, and I'll just give you the electronic page in a moment. CD 2.41 committee report, and then electronic page 12. Perhaps it's better to start back at electronic page 42, paragraph 42, my apologies, electronic page 10. Having set out the background, including providing SNH's input on appraisals, because as you'll recall, as the development is outside the park, SNH has carried out the assessment akin to Miss Anderson. The park carries out its appraisal of impacts from paragraphs 42 to 52, and then in paragraph 55, in the penultimate sentence, reaches the conclusion development is considered to compromise the objectives of the designation and the overall integrity of this part of the park, given the distance from the park boundaries and significance of the impacts. And that is very clearly directed at the first test in paragraph 212. If there was any doubt about that, in the park's hearing statement, which is CD 14.4, and I went, don't have the electronic page numbers.
Mr. Finlay, I think you might have frozen. I'm not sure that the Highland Council can hear us. Is that everyone else's view? If we just remain on the call just now, just to see if they will reappear. Everything was going reasonably well as far as technology is concerned up till now as well.
While we have a moment, Sir, I apologise for waggling my fingers at you earlier. I tend to forget that I've got a microphone.
I was very glad you corrected me when I indicated it was 9:30, not 10:30. So thank you for that, Dr. Gordon. I think because the council participants have not reappeared immediately, I would suggest that we take another a 10-minute break, and that would maybe coming back at 10:55 in order that the problem can hopefully be fixed or addressed. So 10:55, I'll sign on again. Now, I'm going to ask if Mr. Finlay and his team can hear us or can hear me. I see Ms. Caudry back. Mr. Finlay.
Apologise again for that interruption. So again, it was the hotel Wi-Fi. We've moved on to a alternative source of Wi-Fi at the moment. So hopefully we'll be secure in that.
You do seem to be sounding a little bit different in terms of, and it looks as if you may have frozen again, Mr. Finlay. Ms. Caudry, are you able to see if Mr. Finlay's still okay?
Yes,
I can still hear you.
Still here. There's quite a lag on him speaking and actually it coming through on the system.
Yes, we're hearing you perfectly well.
Okay, I think I'm connected on the hotel.
Unfortunately, you have now frozen, Ms. Caudry. Mr. Finlay, can you actually hear us?
Yes, I can hear you. Can you see me now?
Yes, I mean, one option could be we could see if removing your video allows you to speak. I'm not sure. I haven't been advised that from IT, but that might be an option in order to try and reduce the bandwidth that you're using. I don't know if that's an option. Can you still hear us, Mr. Finlay?
Yes, sir, I can.
Yeah, well, we can hear you okay. Are all the parties happy if Mr. Finlay stays off video just now so that we can hear what he has to say? Are you able
some may consider it's an advantage.
I haven't had that said to me, Mr. Finlay. Anyway, you were cut off in your prime, and we thought you had a long pause, but I will allow you to resume your points.
Thank you very much, sir. I'd drawn your attention to the Park's hearing statement at paragraphs 51 and 65, fourth bullet points. That's the position of the Park. As to SNH, it adopted the same general approach in its objection letter, which is CD 234. And
Mr. Finlay, the last thing I heard was CD 234.
That's right. I was just waiting for you to get to the page. So it's electronic page 5. And having carried out an assessment, it reaches conclusions. And in the penultimate paragraph, it identifies impacts, in reading from the third last sentence, as the result of the Glenshero are of national interest and warrant an SNH objection as it fails both paragraph SPP paragraph 212 and the Cairngorms National Park Plan Policy 3.3. And whilst the particular limb of 212 is not identified, in our submission it's clear upon reading their report that they're concerned with the first, that it's failed the first limb. And insofar as there's any doubt as to that, if you go to the joint statement of Nature Scott and the Park, which is CD 15.3, I don't have the electronic page, but it's page 10 of the document. And if you go to paragraph 4.1.12, you'll see that that is confirmed, that the views both of THC, Nature Scott and the National Park concluded it compromised the objectives and overall integrity. thereby fails the first limb of SPP 212. And just to complete the jigsaw and you needn't turn to it, but in the Highland Council's report of handling it, which is CD 2.9, the position of Nature Scott and the park are summarised at the outset of that report, and then it's dealt with at paragraphs 8.109 to 8.1111, and it simply concludes by saying the position of CNPA and SNH is supported. So, sir, in our view, we have the policy, the evidence from all three bodies, policy decision-making bodies, adopting the assessment, albeit that was carried out by SNH on the special qualities of the park, which has been supported in evidence by Ms Anderson, and indeed Mr Trinick didn't even seek to demonstrate any distinction between Nature Scott's assessment and Ms Anderson's, and that the three bodies concerned have felt quite capable of drawing conclusions on the back of such evidence as to the application of the policies. So in our view, you and Scottish ministers have quite ample evidence to deal with those matters, and if you wish further elucidation, all three bodies are represented today to deal with that. But no further elaboration is needed. I don't need to provide any new evidence. All the evidence is there, and the reasoning for it. So I wholly reject Mr Trinick's approach. There's no lacuna in the evidence. It simply serves to obscure the real issue between the parties, which are the extent of impacts on the park, and there is a real issue there, and whether they do engage the first limb of 212 or the second limb of 212, and the consequences thereof on park policy and your overall decision. But there's no knockout blow with respect to Mr Trinick. So I'll restart my video, because that's the end of my submission on that point.
Thank you, Mr Finlay. Now, are there any other points that or questions that you were expecting to hear or give answers to with regard to the national park before I move on to development plan matters? Mr Trinick.
Yes, sir, I'm afraid I think that needs a response. First of all, Carol Anderson has not done what a landscape architect is expected to do in terms of CD 530. She has explicitly not carried out step 4. That is clear on our own evidence. Secondly, I asked Carol Anderson very deliberately who she appeared for at the inquiry. She said Nature Scott. I said, so you don't appear for CNPA? No, I don't. Now, I know that Nature Scott has been asked to represent the views of the National Park at the inquiry, which made me rather puzzled about Carol Anderson's response, but that was no response to my direct question. I don't think that the park rely on the position of it took at the committee stage, nor can Nature Scott rely on CD 234. We're examining here evidence given at the inquiry. That's the evidence in detail, which is before you and which has been examined. We're not examining the report of handling, we're examining the evidence given at the inquiry. In paragraph 4.5 of the premonition, I'll give it a reference, I don't need to go to it, CD 14, CD 15.2, paragraph 4.5, electronic page 5. Carol Anderson says Oakland's assessment addresses the effects of the proposal on the integrity of the national park. So she knew what James Welsh had done. She went on to say immediately, I have not considered the issue of integrity in my evidence. but have concluded that significant adverse effects would occur on some of the SLs in the western part of the Canyon National Park. So she acknowledges she hasn't even looked beyond the study area, she's looked at the western part of the park. And simply to drive back to consultation response at this stage, I think is wholly inadequate. A lot has happened since then. The evidence to which proper weight can be given is that which has been examined at this inquiry. It must be remembered I gave Karen Anderson the chance in cross-examination to address this very point. The opportunity was not taken by her to elaborate on what she said in paragraph 4.5 of her recognition. So the answers given by Mr. Finlay simply don't address the issue of the evidence given at the inquiry. It's a bit like referring back yesterday, as he did, to the EIA. We've gone well beyond that. We're at inquiry now. We're looking at the evidence. So I'm sorry, I maintain my point that the National Park Authority and Nature Spot are disabled. Now, we've been making this point in closing submissions. We won't say any more now from addressing the issue of integrity before you. Thank you.
Thank you, Mr. Trinnick. And I'm sure Mr. Finlay may address matters in closing submissions also, but I think it's probably appropriate for me to move on now to development plan matters. That's item 6 on the agenda. It's really just the first point, A, is just to clarify the relevance of the policies. I think everyone's quite clear that policy 67 is the main policy, but is policy 28, really designed for the assessment of a wind farm of this scale? That's my question, and also the value of policy 57. Should I be really focusing on policy 67? So to the council first, the relevance of policy 28, is it designed for assessing a wind farm, and the relevance of policy 57, please?
So I'm going to pass over to Mr. Heinson, but in short order, policy 28 is relevant for the reasons that Mr. Heinson did, but the main policy is policy 67. That's the headline. I'll ask Mr. Heinson to deal with the detail.
Thank you.
Yes, apologies, sir. I'm going to have to keep my camera off due to the issues that we're having with the internet today. But in terms of policy 28, it's relevant as it relates to matters such as design and sustainable development, predominantly relevant insofar as it relates to the supporting and ancillary infrastructure of the wind farm. It is noted, though, that these matters are also covered by 67. While policy 28 is relevant, it isn't perhaps a wholly determining factor in it, but it is as set out in Mr. Bell's policy hearing statement at paragraph 4.4.3. that the policy is of limited relevance in terms of undertaking a comprehensive policy appraisal against the terms of the development plan. But it is considered that the majority of the matters in policy 28 are covered by policy 67.
Policy 57, again, its relevance.
In terms of policy 57, it has no relevance in relation to wildland. It has been superseded by Scottish Planning Policy, and that's the Highland Council's position on that, and has been communicated through a number of public inquiries since the publication of SPP and the wildland mapping. It is, however, relevant in relation to other natural built and cultural heritage designations. But it should be noted that it largely it does reflect the policy approach set out in Scottish Planning Policy.
Okay, thank you for that. Any comments there, Mr. Trinnick? I was just clarifying that policy 67 is the key policy.
I'll ask Mr. Bell to speak, sir.
Yes, I think that's a very fair summary Mr. Hinson's given. Policy 67 is the lead or dominant policy. Policy 28 is general, I would say very limited relevance, and Policy 57, yes, the wildland matters are superseded, other parts are relevant, so that is an accurate summary.
Thank you for that, and we'll come back to Policy 67, but just a short excursion into the onshore supplementary guidance in terms of its relevance. I think in the hearing statement of the council, you've indicated that separately assessing the proposal against the supplementary guidance may not be that appropriate, but we did talk about the supplementary guidance last week at the inquiry sessions. So there are just a couple of matters I would like to discuss. They probably relate to the criterion, and I think that's on page 21 of the onshore supplementary guidance. Yeah, page 21, and that is CD 4.6. We discussed at the inquiry sessions that we might return to the landscape character areas, and there was a debate and discussion around which landscape character type that the proposal fell into. But I've got just a couple of questions with regard to if we go to actually paragraph 533, which is electronic page 39, and that gives us a summary of the findings from the landscape and visual sensory appraisal with regard to Loch Ness. And below that, on pages below, we get some of the key views. I think if you go to electronic page 41, there are some key views, and we see there one of the views that we looked at was the Great Glen from Ferveny. We discussed that. My question to the council is that, if you like, policy approach with regard to paragraph 534, actually 534, which indicates that the existing pattern of development should be well designed into that, and no undue landscape and visual mitigation agreed for existing schemes. That was a matter that we discussed. Is that policy approach really only from looking from the Loch Ness area and the key viewpoints? It's not looking from elsewhere, for example, Garbour Bridge. That policy approach in the supplementary guidance just applies to the key viewpoints looking from the Loch Ness area. Can I just, it may be a pedantic point, but I'm just keen to get the council's view on that.
So can I start and then, if necessary, pass over to Mr. Heinsohn? It may be of assistance if I just explain paragraph 5.3.9 first of all. I think there's agreement that the guidance doesn't contain any further tests, so that's why we've said it's little to be gained from separately assessing accordance with supplementary guidance. But as Mr. Trinick did in his cross-examination, it's a very helpful checklist of factors that are to be relevant, and indeed we take Mr. Trinick's cross-examination by reference to the criterion as implicit endorsement that it's a sensible checklist against which to test, sorry, not test, but to assess a development. And indeed, whatever one makes of his cross-examination or Mr. Dahl's answers, he managed to deal with all the relevant factors by reference to the criterion. So that's its relevance, even though it's not part of a test as such. The second point is that 534 applies to the whole area concerned, and it deals with landscape and visual sensitivity. So it's not just impact from key viewpoints. It's although the emphasis is on the Loch Ness area, it's landscape and visual mitigation are the words used. So that the injunction and respective mitigation there, it's not a policy requirement. Again, because I emphasize that the supplementary guidance doesn't include a policy requirement, it's guidance. It is to be assessed in we submit in a common sense fashion, and certainly would apply to Meal Fervenay viewpoint 1, and you'll recall that Mr. Dahl gave specific evidence, both in his report and evidence in chief and indeed in cross-examination, about the mitigation from viewpoint 1. And again, you will recall that that was a viewpoint that was considered by Highland Council in respect to the mitigation required for strong lag. So there's relevance in that regard, but in our submission, it's a general point that is not limited in the sense that you have indicated, but I would accept that the emphasis on the part 2 of the guidance dealing with the Loch Ness area is primarily concerned with the landscape within that area and the viewpoints within that area. But the wind farm falls, whichever landscape character area it falls within, and you heard from Dr. Gordon, who pointed out that it's in the SNH character assessment, the most updated one, it now falls clearly in the same landscape area as strong lag. That is guidance that's capable of being applied to this proposal. And I'll ask Mr. Heinsohn if he has nothing further to add. So I've stolen his thunder.
Mr. Trinick, do you have any response to that?
Yes, sir, I do. That in CD46, I think it's electronic page 76, certainly where section 5.2 starts. It's headed Loch Ness landscape sensitivity. 5.30 it says the following table set out the results of landscape sensitivity appraisal for the Loch Ness study area. 5.31 and 5.32 develop that theme, and 5.33. 5.34 starts the areas immediately surrounding Loch Ness. So the whole of section from the 5.2 heading onwards concerns section 5 of CD46, which then goes in to talk about LN1 and so forth, and key views in relation to that area, and also key routes, electronic page 40 only. And so it goes. It cannot be claimed any credibility that paragraph 534 somehow relates to the whole of the Highland Council area. It relates explicitly solely to the Loch Ness area and to the study carried out, which reveals itself in LN1, LN2, etc. So we say no, 534 is not relevant to this inquiry, nor indeed are the key views in 521, because they relate to this section of the report. The relevance of CD46 is limited to an exploration of the criteria, which I fully agree actually with Mr. Finlay on this. Whatever you may say about it, it's not an additional policy, it's a very useful checklist against which to explore various issues, and that's why I went there with Mr. Dow. Thanks, sir.
Thank you, Mr. Trinick.
So can I come back on?
Absolutely.
Very briefly. First of all, I may have not made myself clear. I don't suggest it. The evidence, and particularly the guidance in paragraph 534, applies to the whole Highland Council area. It applies to the whole study area, the Loch Ness study area, into which this wind farm falls. And I'd simply remind Mr. Trinick of his own evidence of Mr. Bainsfair, which is CD 12.1 at 2.2.7 and 2.2.8, having made the point at 2.2.7 that the proposed development is located within landscape character area LN3, for which there's no published sensitivity study. He goes on to deal with the guidance, the particular paragraph that you've referred to, paragraph 534, 2.2.8. And he reaches a conclusion that the proposed development will be broadly consistent with that guidance in 2.2.9. And he goes on to deal with mitigation in Stone Leg, by which I cross-examined Mr. Welsh. But there's no suggestion in his evidence, or that he formed the view, that that paragraph is irrelevant. Indeed, he applied it. And that is evidence of an approach. Now, Mr. Bainsfair wasn't called for a reason we know not what, but for Mr. Trinick to suggest that that is somehow irrelevant when it was evidence the applicant was prepared to put forward, knowingly put forward, no doubt having been checked by its legal team in our submission, is most surprising indeed. But in this regard, we respectfully suggest Mr. Bainsfair got it correct.
Thank you, Mr. Finlay. I was just going to ask another question of Mr. Finlay, then I'll return to Mr. Trinick. The specific approach or policy guidance in 5.34, is that concerning itself with views from in and around the Loch Ness area? And that's my question. That it seems to be the case based on the viewpoints and the statements made, but it's views that are gained from when you're in and around the Loch Ness area. There's a number of routes and views mentioned there. So it's looking outward from these views that is the concern of the guidance there. Is that your understanding, or Mr. Heinsen's understanding, or am I misinterpreting it?
I accept it's primarily concerned with the views and landscape from in and around the Loch Ness area. And so not just from the particular specified viewpoints, but from, which are, after all, just specimen viewpoints, but in general within that area. But because that's what the study is primarily concerned with. So it is not primarily concerned with, say, views from the park, because to put some concrete vision on it's not primarily concerned with views from the park, because it's not a study of the park area, but it is the guidance in 534 is simply replicating in part the guidance, the broader SNH guidance, which you would find in CD 5.3 on siting and designing wind farms. And you might just wish to turn to that because it may be relevant to your next question as well. And if one turns to paragraph 416,
sorry, what CD number was that?
It's CD 5.3 and electronic page 33. And you will see there's a paragraph 416 comes under the title wind farm extensions, and albeit expressed not in the same way of mitigation, but it more in the terms of design rationale. Very similar sentiment is expressed. So the point I'm seeking to make is that guidance in 534 merely reflects a sensible approach that is incorporated in Nature Scott's broader guidance for dealing with wind farm extensions.
Thank you. Thank you, Mr. Finlay. Mr. Trinick, I think you were wanting to make a point.
Thanks, sir. I mean, I have no idea where this last point was intended to go. Your question was simply whether the key views expressed in 521 of CD46 were limited. The idea was to advise on views from the area of Loch Ness. I viewed yes, in answer to your question. Cross-referencing to some other SNH document, I don't see how that really answers your point. And you can't start to construct some argument based on a nexus between one document and another, and they don't explicitly cross-reference each other. I'm not sure where that's going. I'm a bit puzzled. But to answer to come back on the first point, we know there is a debate about whether the site is 3 or 11.6. So I won't repeat that debate. You know our views. You know our position that if the site is very within LN3, then the advice on section 5 of CD46 is inapplicable. I'm not going to go into that again. You have our position on that.
Okay, I think I've heard what I need to hear on that particular matter. In terms of going back to the criterion, now it's actually not the criterion that we looked at, but I just want to clarify that criterion 2 as a gateway site in and around the Garbour Bridge area, that's not regarded as a gateway site. Just want to be clear on that. I don't think it's necessarily listed in the supplementary guidance anywhere, but that criterion, is that in play, Mr. Finlay?
No, it's not as far as Highland Council is concerned. If I was responding on behalf of the Park or Nature Scott, I would give you a different answer, but on behalf of in respect to these criterion, it is not.
Thank you for doing that. I mean, just since we're there and we have Ms. Caudry, I think, and it's more just an inquisitive question more than anything else. I think the kind of stone feature which sort of indicates the entrance to the park is on the other side of the bridge, for want of a better phrase. Was there any particular reason? I know I didn't signal that I was going to ask this question, but just since I've been there, was there any particular reason why the stone feature was put on the kind of west side of the bridge at Garbour Bridge, Ms. Caudry?
While she thinks of the answer to that, we have discussed this. As far as I'm aware, it's not part of a CMPA land grab to try and assimilate more material more land into the park. They're very clear of where the boundary does lie. There's no dispute as to that. Ms. Caudry may not be aware of why the marker was placed in that particular location, but I'll ask her whether she can assist.
I suppose the question there is Garbour Bridge regarded by the park as the gateway to the park? We did discuss where the boundary lies in the inquiry, but is Garbour Bridge regarded by the Park Authority as the gateway into the park from the Military Road? Ms. Caudry.
Yes, so I'm leaving my video off because we've got the internet issues here. I hope that's acceptable. My understanding is that area is a gateway location into the park, and that is why the location was chosen. Not all of the boundary markers, my understanding is, were put exactly where the boundary is on a map, because it needs to be sited in an appropriate location that makes sense to people moving to and from the park, in conjunction with discussion with landowners as well.
Mr. Trinick, I know I didn't have that question on the agenda, but is there any particular points you would like to make on that before I move on?
Well, I mean, it's the first evidence we've heard from Land and Nature Spot on the park that Garbour Bridge is regarded as a gateway. I mean, a small G gateway, in terms of being a higher case gateway for the purposes of criterion 2 within CD46. We've had absolutely no evidence at all from any opposing party on this point. So that would be an entirely new matter. Isn't entirely new matter. We'd like you to give no weight to that answer you just said at all, insofar as it relates to the supplementary guidance.
Okay, thank you for that, Mr. Trinick. We'll move on to C now in terms of policy 67. I think Mr. Kelly had a number of comments to make on it, but a question to the council: how am I to consider the policy wording? Is it a set of considerations? It's not tests, but in light of what Mr. Kelly has said in his hearing statement, which is CD 16.6, page 21, I think. Can you just inform me how I should best use the policy wording?
So if I can deal with that, as I indicated, I think yesterday, we say it's the same way as para 169 of SPP, and they are not a series of tests. They're a series of considerations you need to take into account and ascribe weight to, and simply because you may be contrary to one aspect doesn't mean you will necessarily fail, nor does it necessarily mean if you tick every box save for one you will necessarily pass. And that's the way it's been interpreted by previous reporters and ministers, and we suggest that that is the correct approach to it.
And is there anything additional or different with regard to para 169 of SPP? It doesn't introduce anything particularly different, does it?
Not as far as I'm aware. It predated para 169, and they're both intended to capture the relevant factors. So whilst there may be, and I haven't subjected it to detailed analysis, while there may be slight differences in wording, the intention of both policies is the same. But I should point out that policy 67 is a supported policy, and in its introduction to those tests makes it clear that there will be conformity with the development plan unless the detriments significantly outweigh the benefits. So to that extent, it goes slightly further than para 169 in providing some assistance or guidance, perhaps guidance is the better word, to the decision maker, and expressing the policy support about which we were discussing yesterday for renewables in that wording in the development plan. One should be careful of double counting, but but given its age, one has to take that into account. But it is clearly expressing that central government support for onshore wind farms within that, one could almost say, tilted balance approach.
Mr. Trinick, do you have anything to add to that, or do you agree with Mr. Finlay?
Hand over to Mr. Palliser.
Yes, generally agree, sir. One thing I would say, the reference to the HRES, to how the renewable energy strategy, I think there will be agreement with the council. We've covered it before, that that's no longer a material consideration. But otherwise, yes, agree with Mr. Finlay's position.
Mr. Kelly, you did raise a few comments on the policy. Do you have anything to add or anything different to what Mr. Finlay has said?
Thank you, sir. I don't have much to add. What I set out is my attempt to address what I think is a very poorly drafted policy, although in fairness to the council, they didn't write this policy in its current wording. It was written by the local development plan inquiry reporter who turned down requests, I recall, from Mr. Bell and myself for oral evidence. sessions on this, and the wording you see in the adopted local plan is materially different from the wording that was in the plan put to examination. So I've tried to interpret it, and my concern stems from the paragraph that begins, subject to balancing with these considerations and taking into account any mitigation, blah, blah, blah. The council will support proposals where it's satisfied that they are located, sited and designed such that they will not be significantly detrimental overall, either individually or cumulatively with other developments, having regard in particular to the significant effects on the following. But then the policy doesn't go on to tell you whether any of these considerations are more important than other considerations. As Mr. Finlay has hinted, it gives you no guidance as to whether you pass or fail by getting 10 ticks in the box, or 5 ticks in the box, or 5 crosses in the box. So it's a policy that in my view, falls to interpretation. Notwithstanding the single issue approach that I have set out, the practical situation is that I have never come across a wind farm whose acceptability or otherwise turns on the consideration of only one of those factors.
Thank you, Mr. Kelly. And Mr. Finn, is there anything you'd like to say in close matter?
So I don't think there's anything I need to respond to Mr. Kelly on. So I just noted
Mr.
that
Finlay, anything final from you?
So I don't know whether you can hear me. Can you hear me?
I can hear you now.
So can you hear me?
Yes, I can hear you now.
Thank you. Yes. No, sir, but I did note that you had added by your review to 6B a reference to the strong leg wind farm decision, and whether I don't know whether that you wish to deal with that or whether that was bound up in the criterion.
That was bound up in the criterion in relation to a paragraph 5.34 of the supplementary guidance, because that's I think where it came in. So that's where I've considered it. I think I've had the answers to that. In terms of my question was, where does that sort of guidance come in? And I've heard your answer and Mr. Trinick's on that. So I'm quite content that I've got your answers on that. Unless you want to say anything in particular on that matter, I wouldn't want to exclude any discussion. So if you do have a point that you think I should have asked, then please make it now.
Well, so perhaps for the avoidance of doubt, I will say this, that just so that there's no misunderstanding as to our case on the relevance of strong leg is not just by reference to the guidance area. I cross-examined by reference to strong leg in respect to the park, impact on the park and the wildland area, and the more general visual impact points. And in that regard, so I simply refer you again to the SNH guidance to which I'd referred previously, and to the report on Philago Rig, which is an extension case where the reporter and ministers give consideration to the question of undoing design mitigation. And so I'm not going to take you to the detail of that. I haven't got the CD reference to hand, but I will give it to you in a moment. Hopefully someone else will give that to me for that. I have history of not finding this one, but I raised that because Mr. Trinick appeared to be suggesting, I think perhaps in part in cross-examination and otherwise, that strong leg was purely history and could effect be ignored. Perhaps that's overstating it, but of little importance. I'm told it's CD 9.27, and in our submission, that would be the wrong approach to take, irrespective of the conclusions you reach into it. It's clearly important to have regard to what ministers have said, because that's a material consideration at its most basic. Whether you agree with it or not is obviously entirely a matter for you, and the impact on it is entirely a matter for you, but they are clearly relevant considerations.
Mr. Trinick, do you want to say anything in response to that additional matter?
Not really. So we did it to death in the inquiry session. Nothing more to say. You know my points. I'll deal with it in closing submissions. Thank you.
Thank you, Mr. Trinick. The final point on the agenda, I think we've possibly covered in terms of Mr. Bell's statement, and Mr. Trinick has clarified your position on the special landscape qualities. So I don't think I need to ask anything else on that. I think I'm now clearer as to the position in particular with regard to the benefits of national importance. So I don't think I need to go there unless you want to make any particular points, Mr. Trinick. Mr. Finlay, Mr. Kelly, and Mr. Gordon. One final point then is doesn't really require a discussion. It has been mentioned in the evidence somewhere. Is Circular 3/2012 with regard to planning obligations. Does any party have any concerns about reference to that in my report? It's part of our DPA core documents. I'm not sure it's part of the core documents here in this case. Mr. Trinick.
So I'll deal with it in closing submissions, but in essence, circular is, I suppose, in a broad sense, material. I don't think it's persuasive or of any necessary weight in the Section 36 case, because Circular 33/2012 relates to the town country planning jurisdiction. I've already said that the only constraints on the materiality of the obligations offered are reasonableness, rationality, and whatever degree is appropriate requirements of Schedule 9. So you really have that position. I don't need to say them on the stage. I'll deal with it in closing submissions and the extent of the next section of the inquiry.
Are you content then that it could be added to the core document list without any additional submissions on that? Mr. Finlay?
I accept Mr. Trinick's point that it's not of direct relevance because it's dealing with planning matters, but I suggest that its guidance is of assistance, for the same reason that regard to the development plan can be of assistance and an SPP can be of assistance. One just has to have regard to the different framework. And then in answer to your specific question, quite content for it to be added to the core document list.
Okay, well, that actually takes us to what we might want to do in terms of summing up. And I plan to break just now for 10 minutes maximum, and then we'll return to discuss just the timing of any written submissions and discuss the timing of closing submissions and discuss any additional documents that we've agreed to add into the mix. And any procedure around that. But I do plan to I could take a shorter break, maybe just 5 minutes, if that would suit, and we'll just return back at 10 to 12, and it should only be a 5-10 minute session just to get people's views on timing of further procedure. So that, in essence, concludes the policy and economic benefit hearing. Suffice to say that we're going to come back in 5 minutes to discuss some procedural matters. At that point, we'll also agree the time of the start of the conditions hearing as well. So we will see you all in 5 minutes time at 10:02. My apologies for being a touch later than anticipated, but this shouldn't take too long, I don't think. In terms of both inquiry sessions and the hearing sessions, I've just got a small list of additional documents that I think have been agreed to be submitted in, but there is no need for any further written submission. They're for my information. You may well choose to refer to them in closing submissions. I think if I go through them, I think there was a case that was to be submitted. Was it a case that involved the name of William Grant and Mr. Finlay? That was mentioned. And I think that case was going to be submitted. I'm going to ask the applicant to submit all of these because that will probably make it nice.
I think that was Mr. Trinnick's case. It is the William Grant case, and there's no objection to it.
Yeah,
I will. That's fine.
and then there was a letter that I think Mr. Kelly and Mr. Trinnick referred to. Was it January 2020? I think it would be helpful if we added that. I think that was a letter from Scottish ministers. Is that correct, Mr. Kelly?
Yes, sir, that's fine.
Yeah. Mr. Trinnick, you know the letter that I'm referring to. Mr. Trinnick, you mentioned also the commencement of, I think it's section 34 of the 2019 Planning Act. It amends or to amend section 75. Were you wanting to submit anything into the core documents on that? Will it be
We'll submit the updated version of section 75 incorporating new provisions under section 34 of the 2019 Act.
Mr. Finlay, that's okay?
Yes, well, may assist, and it's obviously just a matter for Mr. Trinnick and his agents, but there are guidance notes attached to the legislation, which will obviously be voluminous, but those relevant to section 75 amendment may also be of assistance to you and other parties.
Yes, of course, we'll put those in. That's fine.
Yesterday about Schedule 9 of the Electricity Act. I don't think that's actually a core document. It often is, so I would ask the applicant to pop that in. Apologies if it is and I've not seen it. It may well be there and I just haven't seen it, but if it isn't there, I think it would be useful to have that as a core document for any member of the public looking in. So if I can ask the applicant to do that. And also we agreed just 5 minutes ago that Circular 3 2012 with regard to planning obligations. So the applicant has indicated by the use of the thumb that he will submit all these documents. Now, are all parties happy? These are documents that don't require initial written responses before your closing submissions. So are all parties happy that I don't need to write a specific procedure in these matters? That these will just be added in by the applicant. I think that will save some time. Thank you for that. The two matters that I may choose, or I probably will choose, to have a further procedure on is asking the council for some additional information on the Melgarve substation and allowing responses to that. That relates to the emails that we have received with regard to information and emails back and forward. I think it's a lot neater if I just require certain information and allow the parties to respond. So everyone happy that that is dealt with by written submissions rather than an email exchange. Thank you for that. Mr. Finlay and Mr. Trinnick indicated that with regard to the draft agreements, the draft section 70 planning obligations that were circulated quite late on, that that would be matters that they would be making submissions on, and to allow the opportunity for both parties to give initial submissions and an opportunity for all parties indeed to respond before closing submissions. then I would plan to do that under some written procedure also, to ask the views of the parties and then allow all the parties to respond to each other's comments. Does that seem a reasonable way to do that in advance of closing submissions, Mr. Finlay?
Well, so I'm happy to, with that route, but also happy to adopt a less complicated route, in the sense of I'm happy to incorporate such submissions in my closing submissions, subject only to the right to respond on a matter of law afterwards. Then, I doubt very much that Mr. Kelly or Dr. Gordon are going to be particularly interested, and certainly I don't imagine that there'll be any significant difference between those parties that they represent and parties that I represent on that issue. If we do it that way, I don't think we'll extend matters further, because if I have to respond to Mr. Trinick's closing submissions on a point of law on this particular topic, it will only take a matter of a few days, and Mr. Trinick can respond thereafter. It would shorten matters, because if we have to wait for that exchange to take place before we can draft, not before we can draft, but before we are submitting closing submissions, that may extend the time period before you get them. So I just put that forward as an alternative, slightly simpler format, and for others' consideration as well.
Mr. Trinick, do you have a view on that, Mr. Trinick?
I had thought that it might be fairer if we were to send initial submissions on the unilateral undertaking on legal issues, so as to enable all other parties to deal with such points in their closing submissions, preserve the right of final reply for the applicant. But I'm happy with whatever procedure you decide. It's going to be fair in the end, so I'm not making a big point of this.
My reason for my initial suggestion was to ensure that there wasn't going to be further exchanges after the final closing submission. So that was the reason why I was doing that. So I think I'll consider what Mr. Trinick and Mr. Finlay have said, and I'll set that out very soon thereafter, which route I'll take on that one. So we'll not give you a decision today on that, but it'll be very soon. Mr. Trinick, did you raise your hand there? No. Okay. In terms of the timing, the Melgarve substation, could that be requested with a short period of time? Normally we would ask for 14 days, but I think the information of what you would wish to submit as a council is probably there.
So I'm beginning to lose you.
To ask for. So is a 7. I think we're beginning to lose you as well, Mr. Finlay.
I'm getting a message your bandwidth once again.
Can you hear me now?
Can I just confirm, sir, you also I'm losing you as well.
And can you hear me?
You frozen, sir.
I've been told possibly my bandwidth is causing a problem, which hasn't been the case so far. Mr. Can you hear me?
Very, very faintly at the moment, sir.
Are you able to hear me now? Is that better?
Yes.
Yeah. Okay. Well.
Yes, much better.
Much better, and the video. videos off. So where were we? Yes, the timing for asking and responses on the Melgar substation is set. We normally would do that within 14 days, but is 7 days appropriate for requesting information from the council? And would a 7-day return from the applicant be reasonable, or from other parties?
So perhaps I can. The information can be coming from, in fact, from Nature Scott, and the information's ready to go. So we would be happier with a shorter time period to provide the information to enable matters to move on. So a matter of a couple of days would be sufficient. I understand it. Ms. Green is nodding.
What I would do then is I would ask for it to be submitted within 7 days, and Mr. Trinick, is a 7-day response time reasonable from your perspective?
More than adequate.
Okay, so that's that timing issue. We had indicated that closing submissions from all parties apart from the applicant would be made 14 days after the close of the inquiry, and closing submissions for the applicant 28 days. So I do plan to push that out a little bit because of these written submissions that we've raised, and if I choose to go down an initial written submissions route for the planning obligations, the planning agreements, then it would push these dates further out. So we're probably looking at rather than 14 days and then 28 days after the inquiry, we're probably looking at a month, maybe 28 days for all parties, and then 6 weeks for the applicant. Does that seem to make sense in terms of timing, or have you got any critical workload issues that would impinge on that?
That's acceptable.
Sorry, it's Fanny Karen.
So that's acceptable from our point of view, and if that's the time limit, then can I suggest that you ignore my intervention about legal submissions and go with your initial view on that, because that would make sense.
I'm happy with your timetable.
Okay, well, I apologise for the problems with the signal at the end, but that concludes our business. The reason why I wanted to do that just now was that Mr. Gordon and Mr. Kelly, I don't think have indicated that they're going to take part in the conditions session. So that's why I wanted to do that just now. Are you all okay with those timetables that we've discussed, Dr. Gordon, in terms of making closing submissions? Now it will be within 28 days, and I'll set these out in a note after the meeting. But
no, I'm content with that, sir, and you're correct. I shall be signing off at the end of this session.
Mr. Kelly, are you content with these timetables that we've discussed?
Yes, sir, perfectly content. And as you say, I'll be signing off once you close this session. And so therefore, I'll take this opportunity to thank you for the conduct of the inquiry. Thank you again.
Thank you, Mr. Kelly, and thank you all for participating. So we'll, for those remaining, are you content that we pursue the conditions session before lunch? I think that's a thumbs up from everyone. And
so I should say that in this session, I'll be stepping out and Nicola Martin will be dealing with the conditions.
Thank you, Mr. Trinick, for telling us that. Does 20 past sound reasonable? Mr. Finlay, okay with 20 past? And we'll see. I don't, just to give you a heads up, I don't have all that many questions at the end of the day. It's largely the matters that are not agreed. So with that said, we'll see you back at 20 past to go through that agenda. I wouldn't anticipate it taking much more than an hour, but we'll just have to wait and see what people say. Okay, thank you very much for just now, and we'll sign off until 20 past. Just stay on the same call. It's not a separate call for the conditions session. Okay, good afternoon. I just want to check that everyone on the call can hear me okay. Mr. Finlay. Mr. Kerr, I think I can see you. Can you hear me? And Ms. Martin? That's good. Well, hopefully we won't have any more bandwidth problems. Good afternoon to you all. This is a hearing session now with regard to planning conditions and any legal agreements with regard to the Glenshero wind farm, which is an application under Section 36 of the 1989 Electricity Act. This is our final hearing sessions. For anyone who is tuning in online, please bear in mind that I have given and other parties have given background to Ms. Martin. I think you're going to have to mute. There we go. There is background given in previous hearing and inquiry sessions regarding the project and the process that we have engaged in over the last week or so. So please refer to earlier broadcasts for the background to the case. But this is a new session, so I would like the parties to introduce themselves. My name is Keith Bray, and I'm the reporter appointed to consider this case and report back to ministers. If I could ask for the applicant.
Good afternoon, sir. My name is Martin. I am the solicitor instructed on this application by the applicant, and I have with me Mr. Graham Kerr, who is the project manager for RES, and is the agent throughout the application.
Thank you. Mr. Finlay.
Yes, good afternoon. So my name is James Finlay, Queen's Counsel, appearing on behalf of primarily Highland Council, but also Nature Scott. I'm one witness, Simon Heinson, and indeed he will be your primary point of contact, and I'll, for your remaining questions, hand over to him unless he brings me in.
Thank you for that. Now, are there any other, I don't think there are any other parties on the call that we need to introduce. Now, just because we're having a hearing session on conditions and legal agreements doesn't imply any particular direction in terms of my conclusions or ministers' conclusions. Ministers expect reporters to write reports and to consider appropriate conditions and legal agreements, if appropriate, in the event that ministers consider that a consent should be granted. So by holding this session don't take any implication from that. So I have circulated an agenda. Can I just double check that everyone has got the agenda? Yes, we'll probably have a thumbs up for that. We're on to item 2 now in terms of the consent condition, which is the section 36 consent conditions. Very quickly, I mean, it may well be to the applicant more than the council, but you're all, or is everyone content that the 30-year period, there's no conflict with any assessment in the IAR? And I did note in certain places that the IAR set out on a 30-year period from the outset. But I just want to double check that no one thinks that any of the assessments were based on a 25-year period. Is that the case? Ms. Martin or Mr. Kerr?
That is the case, sir. It's based on the 30-year assessment throughout. And indeed, all the consultation responses have been on that basis.
And the council isn't aware that any assessments were based on a lesser period. Mr. Heinson?
Yeah, it's our understanding that they're all based upon a 30-year period as well.
That's fine. Just wanted to actually just double check that. And although not on the agenda, just a question to the council that you're happy that a 5-year consent, not a 3-year consent, a 5-year consent. You're happy that the scale of the development or the case put by the applicant warrants a 5-year consent. That's in condition 2, Mr. Heinsohn?
Yes, would be happy with a 5-year consent, yes.
Okay. Well, we can move on to item 3 then. In terms of general matters, there are a couple of conditions that you may often see on other consents. I was just going to ask about. One is serious incident reporting. I'm not making a case for that to be a condition, but was that a conscious decision to leave that out? Do you feel it's not needed? Mr. Heinsohn, maybe? Mr. Finlay, I think Mr. Heinsohn has disappeared.
I'll just contact him, see what he's. Hopefully he's back now. So did you hear the question? He didn't hear your question, so I wondered whether you could repeat it, please.
Okay. I've just got a couple of questions on conditions that you often see on consents. I'm not making any judgment on whether they're required, but there's often conditions that require serious incident reporting. You see them on other section 36 applications. Was that a conscious decision you made to leave that out, or is there a particular need for that condition? I'll start with you, Mr. Heinsohn, and then Ms. Martin.
Would be content for the serious incident condition to be included as one of the what appears to be a standard condition on Scottish Minister consents. I believe we have that included in the document on condition 4. It's on the top of electronic page 2.
I'll just get to that. Could you repeat that reference again, Mr. Heinsohn?
It's on the CD 18.1, and it's referenced as condition 4 at the top of electronic page 2.
Right, I didn't see that. That was my fault there. In terms of looking at that, because it was at the top of the page. My apologies for that. The other matter was you often see conditions that have and you may be going to tell me it's in here again, that the development should be carried out in compliance with certain figures and the EIA report. That's often a general condition. Is that a condition that's included? I don't think it is. But
it's not a condition that's included, but if you would like to include it, so we'd be content for it to be in there.
It's just really whether or not you feel that type of condition has any use.
I believe that it can have use in relation to ensuring that the development is taken forward in accordance with all of the matters set out in the application, which is one of the matters covered by the environmental impact assessment regulations. However, the conditions which require updated schedule of mitigation usually cover off those matters, and when you combine that with the description of development as part of the Annex 1, that is generally sufficient, and we don't necessarily need that additional condition.
Ms. Martin?
We would agree that the description of development would be contained in Annex 1, and there's no need to include the other description within the conditions imposed.
Okay, thank you for that. The other general matters are, and I'll not go through them just now. I may notice that there are matters that I need to make minor changes on, whether it's, I think condition 12 refers to the wrong condition. There may be matters in the reasons that I don't necessarily agree with. These are minor matters, and I will deal with them in the report. So if there's any inconsistency that I spot, I'm not going to go through that today, but I will cover that off in the report. So I'm not going to go through the minutiae. So with that said, on to condition number 6. And it's really to the council a question that is that condition 6 really sort of required given condition 5, and what additional benefit does condition 6 provide, Mr. Heinsohn?
In terms of condition 6, we believe it works in partnership with condition 5. Essentially, we have used this condition over a number of years, as have ministers in granting consents. I think the most recent one was the Limekiln decision that included this one. And the purpose of this condition is to ensure that if more than 50% of the turbines have been removed, that means you're getting less than 50% of the benefits of the scheme, but with potentially with a significant number of adverse impacts still as a result of half the scheme still being there, but with less benefit being delivered. So the reason that condition is in there is to redress the balance if the adverse impacts outweigh of those remaining turbines outweigh the benefits of the remaining turbines.
And do you think that as worded, the test, would satisfy the test for condition? I mean, the last sentence, for example, it doesn't sound that clear. The planning authority having due regard to. So, are you saying that condition passed all the usual tests for conditions, Mr. Heinsohn?
I appreciate the last sentence isn't particularly clear. It had been developed with other that last sentence had been developed with other wind farm developers over the past few wind farm inquiries, including Limekiln, Drumholliston, and Galtaclay. Obviously, we're waiting on the decision for Galtaclay at the minute, and that it was included to provide a bit of flexibility to the developer. If, for example, the failure to generate for more than 50% of the turbines was as a result of a national grid failure that was out with their control, or if there was any other failures that were out with the applicant's control.
So, is this a condition that is peculiar to the Highland Council area?
I would have to check other decisions, but it's certainly one that has been applied to decisions going back to 2000, or not this particular wording, but a version of this wording has been applied to decisions going back to 2004 from ministers. I don't believe it's in front of the inquiry, but the Far Wind Farm has this very, well, a version of this condition attached to it.
And Ms. Martin, do you have anything additional to say over and above what you have in the applicant comments in the document, Ms. Martin?
So in this particular case, there is a situation where there are 2 arrays. Can you hear me all right?
Yes.
There are 2 arrays, and they're not split 50-50. So it doesn't make it's not reasonable in terms of the circular to apply it in this case, because of the logistics of that. The 50% cut-off would mean that the argument that the council running about 50% being a cut-off point wouldn't apply. If we did come to 50%, it would mean that it would be over the two arrays, so there'd be a difference in the effects that would be being the generation would not be comparable with the effects that are being caused by the wind farm. So I think the 50% trigger is not relevant to this layout. Can
I just ask all the parties, well, Mr. Finlay and Mr. Heinzen, were you hearing Ms. Martin clearly there? I was getting most of it, but I don't think I had all of it. Mr. Finlay, Mr. Heinzen, did you hear Ms. Martin clearly?
Yes, I did. It broke up a couple of times, but I could understand what she said.
Do you then have any response to that in terms of the applicant's views on that condition?
Without looking at the ZTV and the impacts of each individual array, I think it's difficult to comment. But it could be acceptable to have an adjustment to the wording of that condition, so that if 50% or more of the turbines in each individual array are failing to produce electricity, that may be one approach that you could take in revising the condition to address the concerns of Ms. Martin.
Ms. Martin, did you hear that from Mr. Heinzen? Do you have any thoughts on that? Would that address your concerns if I considered it to be a reasonable condition in the first place?
If you did consider it to be a reasonable condition to be imposed, which we don't think it is, 50%, the change to 50% would address that concern. So, sorry, did you hear me?
Yes, I did. Yes, yes. I was just looking at other bits of paper. I think then I've heard what I need to hear on that, and I'll make my mind up on that one. Condition 8 now. Despite, I mean, SPP, albeit it's from 2014, requires a robust planning obligation to deal with site restoration. That's not necessarily a requirement of the Highland Council supplementary guidance, but I just want to be sure that the council has considered that option and have come to the conclusion that a planning obligation is not required to satisfy the requirements of restoring the site. So, Mr. Heinzen, are you satisfied that condition is robust enough?
We are satisfied that condition's robust enough. Generally, we take the approach with Section 36 cases that we would be happy to take the details of the financial provisions to be put in place to cover the cost of decommission and restoration by condition, because we haven't seen any Section 36 consents issued by ministers without, we've not seen any Section 36 consents being issued by ministers subject to prior conclusion of a legal agreement. It would be our preference to have a legal agreement, but and that's what we do on the majority of wind farms that we deal with as planning applications, because we feel it is a more secure mechanism. However, the provisions that we have set out in the condition agreed with the applicant include the matters that would be covered by any legal agreement that may be entered into.
Ms. Martin, do you have anything to add to that?
So just to add that the circular for 1998, which is a core document, and I'm afraid I can give you the core document reference if you like it. Paragraph 11 of Annex A does indicate that where a condition can be imposed, it should be imposed rather than going to Section 71.
Okay, condition 11 now then. Let's get that up. And it's really just to ask the council the reasons why there's reference to the, I think it's towards the end, the Road Scotland Act, and that particular reference, I think it's in the last paragraph there. Is that actually required?
A Section 96 agreement will be required between the applicant and the Highland Council as Roads Authority. And the purpose of the Section 96 agreement, as I'm sure everyone is aware, is to protect both parties, so that any damage attributed to, that has occurred can be appropriately attributed to either the developer or whoever else has led to the issues with regard to wear and tear on the road. We have included it in this condition for completeness rather than necessarily an explicit requirement. It's to predominantly make sure that the developer is aware of its obligations in relation to Section 96. However, I do take Ms. Martin's point that she set out in the document that it's not appropriate to secure legal agreements through conditions as per Circular 4/1998.
So have you just said it doesn't actually need to be there? Is that what you're saying, Mr. Henson?
It doesn't need to be there. However, the applicant will need to enter a Section 96 agreement with the council prior to commencement of development.
Ms. Martin, do you have any comments to make on those matters? Okay. Well, I think we can move on to item condition 19 now, item E. I'll just get to that. And that's with regard to the potential for future lighting. And my question is to the council with regard to, does condition 22, if you scroll down, actually deal with that anyway? So, because that precludes any further illumination other than what's agreed in condition 19. So does condition 22 do what you seek to try and do in your view with condition 19? Mr. Henson?
I don't believe it does. Condition 19 is specifically related to aviation lighting, and the area of disagreement between the parties is what if, or our concern is what if one of the interested consultation bodies, whether it be Highlands and Islands Enterprise or Ministry of Defence or NATS or the CEA, so, change their view on the scheme and require visible aviation lighting to be secured, which is a matter that hasn't been assessed by the applicant through their application, because they'd been through discussions with those aviation interests, and they've advised that it could be infrared only. However, we have had experience in Highland where the aviation lighting has came at something post consent where it hadn't been assessed, and it is affecting the qualities of a wildland area, for example. So it's to ensure that the area of disagreement between the parties is to what we're seeking is to have that assessment undertaken if it hasn't been done. So hasn't been done. In terms of the second part of condition 19, I believe that there is overlap with condition 22, but it's only in relation. Condition 22 also has the elements in relation to any symbols, signs, logos, or lettering. So if you were to retain condition 19 part 2, then condition 22 could be reworded slightly to address the overlap between the two conditions.
Thank you for that, Mr. Heinzen. The case that you talk, I'm not necessarily looking for details on the case that you refer to, but was that a case that the lighting changed in that the consultation bodies, whether it be HIAL or otherwise, required lighting that was different to that which was consented, and therefore it was changed? Because that's what you're suggesting here, isn't it? That if something else changes other than what's agreed at this moment in time, you want to deal with that. Was that particular case that scenario, or was it an alternative scenario?
It was that scenario. The application was submitted, assessed and granted on the basis that it would have 25 candela aviation lighting attached to the cardinal points, is my understanding. However, 2000 candela lighting has now been included on it as a requirement. I believe it was the Civil Aviation Authority required it on that particular scheme. And it's the Koromoili wind farm in Ross-shire, and it is something that, because it is a aviation safety issue, we have limited powers of enforcement with regard to such matters, because it would be outweighed in terms of health and safety. So it's to ensure what we're seeking to achieve here is that the matters as they would affect landscape and visual would be appropriately considered prior to the erection of any turbine.
Ms. Martin, do you have anything to respond to on that?
So it's quite clear here that we have had no issues at all raised by the consultation bodies about the requirement for visible lighting. If in the future there is a change in the law that applies to lighting, that's a different matter. But at the moment, we're looking at a situation where there's absolutely no necessity for lighting other than the infrared lighting, which is proposed by this condition.
Mr. Heinzen, before I move on, do you have anything else to say on that matter?
Just limited that if, for example, aviation lighting was included in the assessment at this stage, there may have been different impacts of the scheme that Highland Council, Nature Scot and National Park may have had concerns with regard to impacts within hours of darkness. But that's I don't want to put any evidence forward on that one or assume anything, but it's something further that we would have had to consider.
Okay. Well, I've heard what you've had to say on that, so I think I can take those matters away and consider them. I think I can move on to '20 now, a minor point. I don't think there was a reason set out there. Are you quite happy that I provide a reason, or would you like to provide me with a reason? I'm sure it's to do with amenity. Mr. Heinzen?
I'm happy either way, but I believe this is partially as a result of us using some of the conditions from the recent Limekiln wind farm consent and from ministers which didn't include a reason. So partially our fault in terms of some of the copy and paste errors between minister conditions. I'm happy to provide the reason if it would be helpful. It is related to amenity, and it's essentially it's to ensure that following a noise complaint that noise levels can be measured and assessed to ensure or not whether the predicted noise levels have been met.
Ms. Martin?
I would suggest that a very simple reason would be along the lines of for the protection of residential immunity.
Well, I've heard what Mr. Heinzen says and yourself, and between that, I think I can put together a reason if required. So I don't think I require you, Mr. Heinzen, to submit a separate reason if you're content with that. So that was the only point on that condition 26 now, condition 26. And that's planning monitoring officers, and you may refer to other decisions in this, Mr. Heinzen, but in terms of the reasons that you're provided there, in terms of the council's position in requiring the consent, the condition, you've mentioned there enforcement of the compliance with conditions. Would the enforcement, be the responsibility of an independent consultant or a person appointed by the applicant, or is enforcement not rightly the domain of the planning authority?
You're correct. It's absolutely the domain of the planning authority. I think the point I was trying to get across with my comments there was that if the planning monitoring officer identified any breach, then it would be notified to the planning authority, who could then take any enforcement action if indeed it was appropriate and in the public interest to do so.
Ms. Martin, do you have anything to add to the comments that the applicant has made in the right-hand column? Is there anything additional that I need to know from you on this condition? Mr. Heinzen, I mean, do you think it meets the tests in terms of conditions?
I think in terms of the reasonableness test, which is the one that it was considered to fail on with regard to the Limekiln decision, what we are seeking here is something that the applicant will be doing anyway. The applicant will be undertaking active monitoring of their consent themselves, I'm sure, to ensure that it is being delivered in accordance in accordance with the terms of the consent, including any conditions. So what we'd be seeking here is the details of that monitoring that the applicant is undertaking, provided to the planning authority, to help us monitor the development going forward. I think that's all I'd really be looking to add, and on that basis, with it being something that the applicant is already doing, we consider it to be a reasonable condition.
If it's something that has already been done, is there a requirement for the condition? Would be my question, Mr. Heinzen.
I think there is a requirement for the condition, just to ensure that the monitoring that is being undertaken by the applicant, that information is then passed to the planning authority. I think to achieve that, the condition could be reworded to make it simpler. What we have done, though, through the development of this condition, is take on board concerns from applicants where the condition had been applied previously, setting out that the condition wasn't specific enough. So hence the detail in it. But I appreciate it could be made simpler to say that any monitoring work undertaken by the applicant in relation to planning monitoring or compliance with conditions could be submitted to requires to be submitted to the planning authority.
Thanks for that. Ms. Martin?
Yes, sir. I would suggest that the quarterly and monthly progress reports could be incorporated into the SEM under condition 11, I think it is. Sorry, no, not 11, condition 10. And that would address the provision of the monitoring could be required to be presented to the council on written request under a scheme to be as part of the SEM plan. So if it would assist Mr. Kirk, perhaps.
Mr. Kerr?
Yes, sir. Our construction teams regularly monitor the work that's being carried out anyway and report back to the development manager that's responsible for monitoring the site. So those reports could just be passed on to the council. And as Ms. Martin's pointed out, that could be included as a requirement itself that we submit in condition 10.
Mr. Heinzen, is the key matter here, and as it is expressed in the reason, it's the monitoring, it's to ensure suitable monitoring is carried out rather than necessarily the employment of a particular person. And is that a fair comment to make, Mr. Heinzen?
I think that's a very fair comment to make, and I'd be content with the proposal that the applicants put forward to include the provision of monitoring reports via a scheme to be agreed through the CEMD.
Okay, well, I think on that one, what I'll probably do is, as part of the written procedures, I'll probably just ask the applicant and the council just to get together on a wording on that. I don't think that will delay things too much, given that the inquiry is going to have a couple of written procedures anyway. So if both parties are happy with that to reword matters, then to ensure that the spirit is maintained, but it may well be that the condition is incorporated into an earlier condition. Are we both happy with a bit of rewording? That's good. Now I can move on to condition 28. And I just want to check that the applicant's view is that the annual contribution to the conservation management plan for the Golden Eagle for the region, is that a requirement as far as you're concerned in terms of the responses we've had from SNH in the past, Ms. Martin? Is that a requirement?
First of all, if I could just say that the condition does require slight amendment. I have not raised this directly with Mr. Hinson, so he may want time to consider it. But in the first line, there is the mention of a scheme for mitigation of the potential effect. That should actually be the monitoring of the effect proposal, and that would reflect the response which we provided to RSPB at CD 10.8, paragraph 2.2, to address their concerns on this particular matter. And indeed, the condition has been proposed to address those concerns. This is a condition which is imposed in the Highland region. Aberardo wind farm, for example, I know that's not one of the decisions that you have in the document list, and it has been found to work effectively and to secure the provisions and benefits to the Golden Eagle Conservation Management Plan.
Mr. Heinzen, I'll ask you first of all to respond to the wording matter that Ms. Martin has just raised, and then the more general question is a condition requiring a payment, is that reasonable? Is it grounded in a specific requirement, and will it safeguard the golden eagle population as stated in the reason? I'm just wanting to make sure that this condition, particularly with regard to the contribution, is a reasonable one.
In terms of the wording put forward by Ms. Martin, yes, I'd be content with it being changed to monitoring rather than mitigation. The condition itself is related to the wider impact, the impact of all wind energy development within the Natural Heritage Zone 10, which is the Great Glen area. The Regional Golden Eagle Conservation Management Plan was first established with the Dumnaglass Wind Farm, which I believe was consented around about 2010. The requirement there was secured via a legal agreement, but it was a condition that required a legal agreement to be entered into to secure the funds. Subsequently, as Ms. Martin has mentioned, Aberada Wind Farm, Tomlin Clark Wind Farm, and Dell Wind Farm have also made contribution, or have conditions to require them to make contributions, and they were in relation to Aberada, it was a reporter's decision, and they requested that it was via condition. In relation to Tomlin Clark, it has been secured by a Section 69 agreement, because that was a condition that required the entering into an obligation to provide that annual contribution. And other wind farms in the area don't have, some of the more historic wind farms in the area certainly don't have a condition or a legal agreement attached to them. However, they are involved in the Regional Golden Eagle Conservation Management Plan group, and the contribution from those wind farms is in-kind contribution through submission of monitoring work, contributions towards research, and also contribution to education with around golden eagle impacts within the area, both impacts of the golden eagles, but also impacts on the golden eagles. In terms of the wider, actually no, sorry, so that's probably all the points I have there in response to your questions. I believe I've answered them all.
Thank you, Mr. Henson. I mean, Ms. Martin, do you have any view on whether or not the payment is required to mitigate impacts of your proposal?
So the payment is it's a suspensive condition. So it's a suspensive condition requiring the scheme which is required to include payment. It is an offer that has been made by the developer and has been included in the EIAR at volume 2, which is 71.3. Paragraphs, page 3, I think, on that one. And it does address the concerns expressed by RSPB in their consultation response at CD 2.28.
Can I just come in here, so just briefly? I understand the question you're asking, and the answer that Nicola Martin has given, I also fully understand. It's one of those questions that, in some ways, we will not answer. The offer is being made, and we're happy to stick to the offer which has been made. If you're asking about necessity and you really want to push for an answer, we'll give you one, but I'd rather leave it there.
Mr. Heinzen, anything in response to either what Ms. Martin or Mr. Trinick has said?
Nothing further to add there, no.
Okay, well, I can take that away and consider that. I think we can move now on to, is it item 4 in Annex 1? A simple question, if ministers consider that the removal of 4 turbines was to be appropriate, if ministers consider that a consent was appropriate, does that require a change to Annex 1? Simple question, I hope. Ms. Martin, perhaps.
No, it doesn't. The Annex 1 describes the development and the proposed condition, which is proposed as condition 15, so CD 18.3A, secures the reduction, the removal of those 4 turbines. But the actual Annex, Annex 1, describes development as in the application.
Do you agree with that, Mr. Heinzen?
Yes, I agree that's an approach that could be taken. The other approach that could be taken is that Annex 1 is modified. However, I think if you're to modify Annex 1, I believe that would probably lead to the requirement for the offer of the removal of those 4 turbines to be made more formally, and may lead to supplementary information being submitted and consultation being required. Equally, you could make my understanding of the Act is that you can make a recommendation to ministers, and ministers can then simply give an effect to the recommendation that you give, or recommendation that you make, sorry, and that could in itself modify Annex 1.
Well, thank you for that. I think I've got your views on that. But generally speaking, I think Ms. Heinzen, you were saying that you don't have a problem with what Ms. Martin says. Okay, thank you. Legal agreements next, in terms of the need for any legal agreements. We've touched on restoration, and you've given your views on how matters can all be dealt with by condition. We've discussed 2 legal agreements that have been submitted by the applicant, and we've agreed, I think, in an earlier session that I will be seeking submissions on the appropriateness and the content of those agreements. I didn't plan to go into the detail of these 2 agreements just now, unless there was any particular questions that you think I should ask. But beyond those 2 agreements, is there absolute clarity that there is no need for any further planning obligations or planning agreements to be in place? Mr. Heinzen?
Yeah, I agree that there's no, beyond those agreements, there's no other requirements for planning-based legal agreements. But obviously, we discussed the Section 86 agreement of the Roads Act earlier, which would be a requirement, but that could be pre-commencement. It doesn't have to delay the issuing of any consent.
And Ms. Martin?
No, nothing to add, sir. That's correct.
Nothing to add. Okay. Well, as I said, there will be some written procedures on that. Given that they have arrived reasonably late, I think it's fair that we do that through written submissions. In terms of the number of turbines, that's item 6. If it's just a straightforward question, would that condition require really an amended layout to be submitted is if ministers were to consider such a condition, would that require within the condition the submission of a kind of revised layout in order that it's clear which tracks and such like are not being implemented? Do you think that would be a requirement? Perhaps Mr. Heinzen, I'll ask that of you first.
I believe that given the reference to figure 2.1a, which shows the associated tracks, crane hard standings and the turbines, I think that's sufficient, and I don't believe that any further plan would be required to be submitted.
Ms. Martin, are you content with that?
Yes, sir, I agree with that.
Okay. We'd be glad to hear that I don't have any other matters to raise. That's been a reasonably short session. Do any of the parties have any burning matters that need to be addressed that you think I should have addressed? Mr. Heinzen, first of all.
Nothing further from the Highland Council, no.
Ms. Martin, for the applicant.
Nothing, sir, thank you.
Okay, well that allows me to conclude this hearing session, and that concludes the inquiry sessions as a whole. And as I indicated earlier on today, there will be some written procedures and some timetables with regard to submissions, and they will be sent out to the interested parties in due course, quite quickly actually. Okay. If I can say cheerio to everyone, and thank you for bearing with us with regard to the technology. I think we've managed to get there in the end. So thank you all for your assistance in that matter.
And thank you, sir. And thank you for bearing with us in particular this morning with our communication issues. I understand that a new version of PlayStation may have come out today, which may have taken up more bandwidth than usual, but that may have had nothing to do with it.
Well, that's something for the afternoon, Mr. Finlay. So thank you for that, and we'll see you all at some point in the future. Bye-bye.